This is Paul. I just got here and it's 2:27. I was going through some court rules in Lewis and Clark counties. Yeah. And one of the court rules says that if the individual that motions the court, yes, and that would have to be the petitioner, right? Heidi Budnick, yeah, doesn't appear in court. And I don't get actual notice of a hearing, right? And then I don't appear in court. It gets stricken from the docket. Now I know there's some people upset, but you've been playing, well, we're going to screw over the family, and in the process of that, we're going to screw over the individual known as the accused. That would be my name. Oh. Now, these court rules in other counties, yeah. If the individual known as the motioning party to a court hearing, yeah, does not appear in court, it's removed from the docket. There's two words. It can be stricken or it can be something else. I'll have to look at the email. Yeah. But if both of them don't have notice of the court hearing, then there's a big question. Well, how'd that happen? And then if one of them, known as the party that does the motioning of the court, yes, doesn't appear and the respondent doesn't appear, then there is no court hearing. Now, I found this interesting that the lower left-hand side, yes, on a lot of these forms requires the signature of the individual known as the petitioner. Right, right, right. And I didn't see a signature of the protected person. I didn't see a signature of the actual individual that motioned the court. Yes. Now I see a signature here, and I see a different signature there. Yeah. But I don't see a signature there. Pooch. Do you think they put this in the court rules about having to have an actual signature of the moving party so that it would be legal, yes, for a court commissioner to sign a court order? Ooch. You remember that getting sued for violating the definition of the law? Yeah. Now, I think somebody's been playing, oh, we're going to make so much money off of the actual pain and suffering, the torture and terrorism of refusing to enforce court rules. Now, I know you might be excited, but we have 2 hours to go, and it's going to be a long 2 hours. Usually it goes really, really fast. Yeah. But I think it's going to go really slow. Now, I went through all my Gmail accounts, and every one of them will remove the screen prints. And I thought that was really mean of Gmail. Now, why are they doing that? It's difficult. Oh, look at all the mail delivery fails on this. Oh, look at somebody didn't get my email. Considering the number of times that I've documented the obstruction of my rights as an American citizen. Did you want to enforce the definition of law today? Because just reading through these different superior court rules, yeah, I don't think a judge, a court commissioner, that's really all there is, yeah, can actually sign a court order without the motioning party signing it. Now, there is like a chronological way that this happens. Yes. Having the evidence, oh, and refusing, oh. Exactly what is that? Who is it that signs the protection order first? Is it the motioning party or is it the court commissioner? Now, oh, the issuance of court orders. I'll see if the pictures work. Because when I read this, and it could have been Lewis County or it might have been Clark County, I was a little pressed for time today. I only had so much time in the senior center. Yes. That when I found out where the signature has to go, do they put it on the left side for some reason? Why isn't the signature of the petitioner on the right side? I mean, it's confusing, isn't it? As a judge, as a court commissioner, are all the court forms, do they all have the signature requirement of the known petitioner on the same side of the forms? Now, you would think these court rules are not that important. Isn't that right? Yeah. But when they say the left side, I kind of think that somebody a long time ago, yes, had decided the left side was for the motioning party and the right side was for the respondent. Now, just a second here. I'm trying to get it and it's going really slow. Yes. Now, a couple other things. I can't actually respond to a motioning of the court if I don't get notice of court hearings. And I spent a little time last night thinking about Jack calling me at 20 to 5 last night. Which, you know, I don't really think anybody's been protecting my rights to actually respond. Now, as you can see from the screen prints, okay. Oh, look it, they removed the screen prints. You can't see. Oh. Now, did they put them back? Oh, just a second. Oh, there it is. My bad. This must have been a good one. Oops. I thought we'd just go through the email. Now, the summons and petition were mailed pursuant to an order for service by mail. Now, this has to do with dissolutions of marriage. Yeah. And we went through this whole motioning of the court. Yes. And then declaration of mailing. Yeah. And I know in civil court cases, right, where it's involving a court ordered mailing, like you have to have two required personal attempts of service. Yes. What proof of mailing was there and what address did it go to? Because I never got it. Now, somebody might have said, well, he's homeless. Let's see, in 2012, Mike kicked me out of the fifth wheel in December of 2012. Yeah. Now, this was the protection order, right? 914 declaration of mailing, 925 of 2012. Where did that get sent to? Because it should have been 1023 Kitchen Dick Road. Yes, I was living in a fifth wheel at that time, volunteering at Kings War Foursquare Church 8 hours a week. Yes. And then the temporary order, parenting plan, motion hearing, trial Kirk setting. Yes. Now, I no longer live there after about the 20th of December of 2012. Look at mail returned unclaimed on 114 of 2013. Now, my Uncle Wayne kicked me out of my grandmother's house, and when I got back here, I stayed at a friend's place for about 3 weeks. And then she kicked me out, and I ended up at the Serenity House. Oh, from about, no, it might have been February of 2013. But I do know I was homeless for the last 5 years, 5.5 years. Yeah. Now, I just wanted to know this findings of fact and conclusions of law. Yeah. This says, okay, the summons and petition were mailed. The summons and petition were personally served upon the respondent. The default had taken place. Default. Dependent children of the family are identified in the proposed decree. Yes. Now, formal pleading signature requirements and any order or other paper presented to a judge for signature shall contain a signature on the left hand of the page by the individual presenting the document. Yes. Did the petitioner present the document without her signature on the left hand of the page as if she wanted the court commissioner? You mean the petitioner, known as the moving party, is the one that presents to the court commissioner? Yeah. And so a place for the judge's signature shall be below the last line of the order. Yes. Now this would be below the last line of the order. Yes. The rest of it's the order that goes above that. Yes. Or other paper on the right-hand side of the page. Yes. Attorney signing shall include their Washington State Bar Association membership numbers. Now look at WSBA number, left-hand side, petitioner. Yes. And then this order is in effect, expiration date, boom, right there. Oh, Oh. Protected person, yeah. Left hand side. The orders in effect, bottom, yep. You know, it looks like these court rules are any order or paper presented to a judge or court commissioner for signing shall contain a signature on the left side of the page by the individual presenting the document. Yeah. Um, the individual that presented this document for the court commissioner to sign, yeah. Was it the petitioner or was somebody else's handwriting involved? Yeah. Because I don't think this is Heidi's handwriting. Uh-huh. Uh-huh. Um, has anybody been practicing law in the state of Washington that is not legally allowed to practice law as defined in the Supreme Court rules? I think this is void because somebody is not a court facilitator or court administrator and does not have the legal right to write anything on it. Ouch. Now I'm going to want to sue you for that, okay?